phobia is the illogical, unreasonable fear of old people and of getting old. And we have an epidemic of it.
Maggie Kuhn, co-founder of the Gray Panthers and one of the great leaders and spokespersons of our time, is making a unique contribution to American society. She is challenging age-related prejudice and generating national support for the needs inherent in the aging process, from the United States Senate to the American Medical Association. With her extraordinary energy and insight, Maggie Kuhn portrays the admirable spirit, commitment, and new image of aging in America.
Our focus is not on old folks' issues. We're not a gray lobby. We're not working for the special interests of old people. We're working for the special interests of people, humanizing, hopefully, and healing our society of its divisions.
Thank you, Emily, for that. Hello, all. Good afternoon. Welcome to our March 31st Transformation Tuesday. Today, we're discussing a very timely topic. Whose death is this anyway? The Medical Aid in Dying Act in New York State. This landmark bill that Governor Hochul signed only last month. This act is the result of the concerted efforts of advocates and organizations such as End of Life Choices, who joined together to ensure that New Yorkers can have the freedom to make personal decisions about their own care, to shorten their deaths, not their lives. We're honored to have David Levin, Executive Director Emeritus of End of Life Choices, presenting today. And we expect a lot of questions, so please type them in the chat and we'll do our best to read them. Most of you know me, I'm Michelle Arnaud, and it's my privilege to lead the New York City chapter of the Gray Panthers, which was founded by Maggie Kuhn, whom you saw in the opening clip. Our chapter has hosted these free public education webinars on the final Tuesday of each month since 2021, and we're committed to continuing into the foreseeable future with your financial support. Our intention is to educate, engage, and empower our attendees around issues affecting older adults and intergenerational justice by offering these free, accessible programs. And we appreciate your donations to keep us afloat. Also, a quick announcement that next month, in addition to the Tuesday, April 28th webinar, we're participating in a virtual program with the Legacy Project, which is entitled Bridging Generations, Building Change. And you'll be receiving information in your email about that April 27th program. So keep your eye peeled on your inbox. Also keep in mind that all our webinars are recorded and posted on our YouTube channel by our multi-talented digital manager, Emily Trask. And thank you, Emily. And now I'm going to pass the virtual mic to our board member, Janine Ferrari, who also serves as resident advocate at CIAD. She'll introduce our distinguished speaker. So thank you, Janine.
Thank you, Michelle. We're really psyched to have David on with us today. He is a leading advocate for patients and an expert on advanced care planning, on patient rights, palliative care, and end-of-life issues, including medical aid in dying. David has played a key role in having legislation introduced and enacted in New York to improve pain, palliative, and end-of-life care, including the Palliative Care Information Act. David lectures frequently to diverse and health legal professional groups, students, and the general public, and seniors. He is a graduate of the University of Rochester and Syracuse University College of Law. Thank you, David, for joining us today.
Thank you very much, Jeannie, for having me. I'm delighted to be here and really didn't expect to see so many young faces. Looks like most of you are under 40. I could be wrong. I know my eyesight isn't as good as it used to be. And I'm one of the older people, I think. I won't be 83 until next month, but I know I'm relatively old because I went to law school with Joe Biden. We graduated in the same class. And just a little bit more about my background. I was a legal services for the poor lawyer for 10 years in Rochester, New York. And then for 20 years, I was the executive director of Prisoners Legal Services of New York. And my career has really been about, no credit to me because this is what I wanted to do, but it's been about seeking justice, justice for poor people, justice for incarcerated persons, and now health justice for those particularly at the end of their lives. So I'm going to be talking about medical aid in dying, and I'm going to talk about the act, but I'm going to wait a little bit to do that, except to give you a couple of important provisions about the bill, because I think it's important that you all be sufficiently educated about what medical aid in dying is so that you all can educate others and be advocates for medical aid in dying. Because although polls show that up to 70% or even more of the public supports medical aid in dying, there are probably about 30% of the public who does not. So you're going to have friends and relatives who either are neutral or are opposed to it. And I think you can do a good job of persuading people and educating those, particularly who don't know that much about, if anything, about medical aid in dying. And in fact, in states where medical aid in dying is authorized, and now there are 13, including New York plus District of Columbia, about 50% of those in those states where it's authorized do not know that medical aid in dying is legal in their states. So there's a lot of education that needs to be done. Unfortunately, we still have a 100% mortality rate in this country. I don't think that's going to change despite all of our wonderful healthcare institutions. And so people continue to die every day. In fact, we have 200,000 deaths in New York State each year. And until recently, people died relatively quickly of catastrophic illnesses, of heart disease, cancer, lung disease. People didn't live for a very long time and suffered from incurable conditions that really couldn't be treated that well up until the last 50 or 60 years. But now about 90% of Americans die from chronic, progressive, incurable diseases. People are living longer, but not necessarily better. But when we talk about chronic diseases, we're talking about heart disease, many forms of cancer, lung disease, kidney disease, etc. So that people are living with these chronic illnesses, sometimes for decades. And yet many chronically ill, seriously ill people have, among other things, poorly controlled symptoms, particularly pain, psychiatric disorders, and psychosocial and spiritual distress, concrete needs in the home, and challenges in care communication. Just 5 years ago, a study by Duke University found that the United States ranked 43 of 81 countries in how well health centers provide for the physical and mental well-being of patients at the end of life. That's really pretty disgraceful, given the fact that we could be doing a much, much better job. Now, hospice and palliative care do an excellent job, generally speaking, and in fact provide quality care and improve the quality of lives of people who are dying for those people who are receiving palliative care or hospice near or at the end of their lives. So medical aid in dying is a process which everyone should have the right to if they're an adult, terminally ill patient with decision-making capacity. There is no really good reasons why people should not have this right. For those who are dying, the issue isn't whether they're going to die, but how they're going to die. And are they going to be able to make their own decisions as to how they die and when? Medical aid in dying should be an available option, in addition to other ways in which death might be hastened. Think about it. We all have the right, at least since 1990, to stop or never start life-sustaining treatments, whether it's a feeding tube or ventilator, antibiotics, pacemaker. It really doesn't matter. We can stop or never start at any time. And we have the right to voluntarily stop eating and drinking. So you can hasten your death if you feel that you can no longer go on living and maybe medical aid in dying is not available, because that is your right as a matter of autonomy, and no one can force feed you if you have decision-making capacity. And increasingly, particularly in New York over the last decade or so, people have been dying by voluntarily stopping eating and drinking, and it's generally speaking a fairly good way of dying. Palliative sedation is another way in which death is actually hastened, even if by not more than a week or two, where people who have uncontrollable symptoms, usually pain, are sedated to unconsciousness, and they die eventually of dehydration, again, within, generally speaking, a week or two. So medical aid in dying occurs when a terminally ill, mentally competent adult patient who is likely to die within 6 months, as determined by 2 physicians, takes prescribed medications which must be self-administered to end suffering and achieve a peaceful death. So those 2 physicians must make 2 determinations. One, they have to determine that the person will likely die within 6 months and that the person has decision-making capacity. So medical aid in dying really is a reasonable end-of-life care option and a better choice for some terminally ill patients who are really suffering at the end of their lives and just feel they cannot go on living any longer. Most importantly, it's been proven to be a safe, ethical medical practice which benefits patients and families and causes no harm to anyone. So medical aid in dying occurs throughout the country, but in states where it's not authorized, it's done underground, unregulated, and may not be legal. The practice, of course, should be legal above ground and reasonably regulated, as it is in those states which have authorized medical aid in dying. Physicians and family members should not be at risk of punishment. Many years ago now, in the late 1980s, one of my colleagues, Dr. Tim Quill, who then later became the head of palliative care at the University of Rochester Medical Center, actually helped one of his patients to die by giving her life-ending medications. After that, he wrote about what happened, and his article was published in the New England Journal of Medicine. Following that, the district attorney of Monroe County, and by the way, I'm from Rochester, and this is Monroe County, the district, and I knew the district attorney at the time, Howard Rellin, prosecuted Dr. Quill for assisting a suicide. It was brought before the grand jury for an indictment. And what do you think happened? Was Dr. Quill indicted, as he might have been, because it does appear, based on the statute, that he was assisting a suicide? In fact, the grand jury refused to indict Dr. Quill. He testified on his own behalf, and it was very clear to the grand jury that what he was doing was respecting his patient's right and wishes, because she wanted to die, because she was suffering so much, and her suffering could not be adequately controlled. The grand jury, I'm sure, thought that Dr. Quill was doing what was right for his patient. So medical aid in dying is now legal in 13 jurisdictions. Illinois, Delaware, and New York just passed medical aid in dying laws this year. Medical aid in dying has been authorized in Oregon since 1997, almost 30 years, and in Washington since 2008, and in some other states for at least 8 or 10 years as well. So we now have a lot of experience with medical aid in dying, and virtually all of it has really been positive. None of the problems anticipated by opponents or skeptics have emerged, which we'll talk about a little bit more later. But I want to make clear that medical aid in dying is not assisted suicide. Terminally ill patients who consume the life-ending medications are not suicidal. They are going to die. They prefer to live, but they can't. And stark differences exist between suicides and medical aid in dying. People who die by suicide often have a mental illness. They could continue to live, but choose not to. They often die in isolation, often impulsively and violently, and generally their deaths are tragic. To the contrary, medical aid in dying is only available to terminally ill patients who will soon die. Their disease is what's killing them. The process generally takes about 7 weeks from the first time that the patient asks for medical aid in dying from his or her attending physician. And by the way, about 1/3 of patients who request the medications never take them. And it always occurs, of course, after consultation with the two physicians that I mentioned. And now there has to be a third healthcare professional, which I'll talk about in a little bit, that's involved. And it's almost always with family support. And for the vast majority of people who die and their family members, it's an empowering experience. The term assisted suicide is rejected by numerous organizations, including state laws which authorize medical aid in dying. In 2017, the American Association of Suicidology issued a statement that suicide was not the same as what they termed physician aid in dying. While the statement has been withdrawn, many of the disparities pointed out are still valid today. And I'm going to read from this long document that was prepared in 2017. It's actually 5 pages because I think you'll see some of these substantive differences between assisted suicide and physician aid in dying, or what we now term medical aid in dying. They call it PAD. And they say in PAD, the person with a terminal illness does not necessarily want to die. He or she typically wants desperately to live, but cannot do so. The disease will take its course. Suicide, by contrast, even when marked by ambivalence, typically stems from seemingly unrelenting psychological pain and despair. The person cannot enjoy life or see things that may change in the future. In PAD, the individual who is already facing death often experiences intensified emotional bonds with loved ones and a sense of deepened meaning as life is coming to an end. In suicide, by contrast, the individual typically suffers from a sense of isolation, loneliness, and loss of meaning. The term suicide may seem to imply self-destruction, and the act may be cast that way in some cultural and religious traditions. Ending one's life with the assistance of a physician and with the understanding of one's family is often viewed more as self-preservation than self-destruction, acting to die while one still retains a sense of self and personal dignity. So they make 15 points of distinction between the two ways of dying. So the laws allowing medical aid in dying have really worked just as intended. It's been quite incredible when you think about it. There is evidence that deaths by medical aid in dying are at least as good, and in some cases better than other deaths. There's evidence that family members of those who request medical aid in dying feel better prepared and accepting of the death, and there are no negative effects. About 90% of those who end their lives by medical aid in dying are receiving hospice care. And what that means, of course, is that even hospice can't meet all the needs of all dying patients, despite the fact that probably it can meet the needs of 95% of the patients that are served in hospice. And almost all people have health insurance and most are college educated. But I want to mention one thing about hospice and in the context of medical aid in dying. It's 11 years ago now when the former CEO of the Oregon Hospice Organization wrote an article in Jackson, which was published in the Sacramento Bee. And she said, people who oppose laws in California, Oregon, Washington, Montana, and Vermont authorizing medical aid in dying for terminally ill adults often claim there are better alternatives to relieve suffering. She said, I was one of them. In fact, I served as chief executive officer and chief spokesperson for the Oregon Hospice Association. I believed it was unnecessary if terminally ill Oregonians had access to high quality hospice and care. However, I came to realize that it was arrogant of me to believe that hospice and palliative care professionals could meet all the needs of the dying. Oregon is consistently rated among the best states for providing hospice and palliative care, yet even with the best care, some patients still suffer intolerably and want the option to take prescription medication to die painlessly, peacefully, and quickly in their sleep. She goes on to say that many opponents claim that palliative sedation will ease the suffering of patients when other means fail to do so. However, it is an unacceptable option for most terminally ill adults whose primary concerns are losing autonomy, quality of life, and their dignity. And finally, she says, while some healthcare professionals expressed fierce opposition to medical aid in dying prior to the law changing in Oregon, since then, those voices have softened in the face of indisputable evidence, and no representative medical organization has called for the law to be repealed. So that's Ann Jackson, who was once an opponent and now has become a staunch advocate for medical aid in dying. There's a comprehensive cancer center in Seattle, Washington, which implemented a program for patients to access medical aid in dying, and they found that their program was working quite well accepted by patients and clinicians. That program would have stopped, of course, if they did not think the program was working well, and if medical aid in dying was not a good end-of-life option for some limited number of patients. And I should mention that about only 3 out of 1,000 patients who die by medical aid, who die in states where medical aid in dying is authorized, actually end their lives by medical aid in dying. So it's a very, very small percentage, far less than 1% of the population, who will eventually choose this option, even though it gives great comfort to thousands of dying patients to know that this option is available to them if it might be needed at some point. As I mentioned earlier, none of the problems expected or anticipated by opponents or skeptics have emerged. There's no evidence of disproportionate impact on vulnerable populations. There is no proven case of coercion or abuse. And with regard to those people with disabilities, and some in the disability rights community have opposed medical aid in dying, a letter from the executive director of Disability Rights Oregon, their protection and advocacy agency, stated in 2016, Disability Rights Oregon has not received a complaint of exploitation or coercion of an individual with disabilities in the use of Oregon's Death with Dignity Act. One other thing I want to mention is that a former president of one of our sister organizations, Compassion and Choices, Paul Spears, who died in 2013, was a staunch supporter of medical aid in dying. He was a forensic neuropsychologist on the faculty of the Boston University School of Medicine and MIT. And he was a wheelchair user after a fall from a horseback some 15 years before his death that left him paralyzed from the chest down. This is what he said. As a wheelchair user, the principle of choice is one that is very important to me. It is also the driving force and the core principle of the Americans with Disabilities Act. Those in the disability community will get no argument from me that the disabled are often viewed as having an existence that others may not feel is worth living, that we are more vulnerable to discrimination and have been discriminated against by many institutional groups, including the medical profession. Some seem to fear the legislation similar to the law in Oregon because they believe it will invite further discrimination. But he goes on to say, if I were to face such a scenario, meaning that he was dying in the future, were I to lose what little control I have left over my body, then I will want the right to make such a choice. But it would be a choice that should only be available to me if I carried a terminal illness. It might not be your choice or that of 10 other people with disabilities or who use wheelchairs. But just as I would never presume to make a choice for you, please do not presume to make a choice for me. You do not have to somehow protect me from myself, from others, or from society just because I am a wheelchair user. I prefer to protect myself. So, of course, we must be vigilant always to hopefully ensure that people in vulnerable populations are not being abused or coerced, and that includes people with disabilities, the elderly, poor people, people of color, etc. But to date, there is no evidence that this has been or is likely to be a problem. There have been, again, no substantiated complaints in any court or administrative agencies. And there is simply no connection at all between other serious problems, barriers, and discrimination that people with disabilities or others in vulnerable populations face in healthcare and medical aid and dying. They're two totally separate things. And of course, people with disabilities are not eligible for medical aid and dying unless they happen to be terminally ill. And from what I understand, very few people with pre-existing disabilities, wheelchair users or others, have accessed medical aid and dying in states where it's authorized. There is no evidence of any slippery slope. Medical aid and dying is only for the terminally ill, and what happens in other countries really isn't relevant here. We have our own distinct history, culture, values, religious and otherwise, and it is difficult enough to get medical aid and dying laws enacted for only the terminally ill. And so how could it be expanded? Well, only in two ways. One, through legislation, and that's not likely since it's hard enough to get medical aid and dying laws enacted, or two, by court decisions. And there's not been one higher court case that has ruled that even medical aid and dying is a state or a federal constitutional right. So those who are concerned about a slippery slope, I understand the concern. It just does not seem to be in any way justified. There is clearly widespread support for medical aid and dying. As I mentioned earlier, about 70% of the public generally, a substantial majority of New Yorkers support it. Physicians in the US support medical aid and dying by about a 2-to-1 margin. In New York, by a 3-to-1 margin. Doctors supported the Medical Aid and Dying Act once they learned the provisions that were in the act and all of the safeguards and requirements that are in the bill. And I want you to think about this. If you want to die by never starting or stopping treatment, there are no legal statutory requirements that say you have to wait 5 days, you have to get an opinion from 2 different doctors that you have decision-making capacity and are terminally ill. You don't have to go through this process that you have to go through in order to access medical aid and dying, in order to die by never starting or by stopping life-sustaining treatments. Obviously, there should be a process that's gone through to make sure that nothing can be done to reasonably improve your quality of life so that you would not want necessarily to hasten your death, because we don't want people to prematurely die. But even so, once that process has been completed and it's shown that the person still decides that they don't want this life-sustaining treatment, it is their right, again, never to start it or to stop it. So there are many arguments still that are raised and have been against medical aid and dying. Most of them really just have been shown not to have any basis whatsoever, at least currently. And if you think about this argument, preserving life is paramount, and that was raised, by the way, in the Supreme Court cases, where the United States Supreme Court in 1997, in a case that may have been brought prematurely to try to establish medical aid and dying as a federal constitutional right, that this was an argument that was made and the court seemed to buy this argument that the state has an interest in preserving life. But when you think about it, what right does the state have in preserving the life of a dying patient who no longer wants to live and will not live much longer in any event? There is the argument about preventing suicide. But again, we're not talking about suicides here. We're talking about people who are dying and their disease is really what's killing them. They just want to decide how and when their lives are going to end. There's an argument that maintaining physicians' role as their patients' healers is required. Well, of course, there comes a point when physicians can no longer heal, but they can prevent or try to prevent more suffering. Another very important role and ethical obligation that doctors have. And they can try to respect their patients' rights. There's the argument that doctors should not be involved in intentionally causing the death of their patients. But we actually don't know what the intent of a doctor is when the doctor agrees to prescribe life-ending medications. The doctor may not want the patient to die, in fact. And we don't know the intent of what doctors are when they withdraw a ventilator, for example. The doctor may actually want the patient to die or not. And in any event, it really doesn't matter what the intent of the doctor is. It's the intent of the patient that really matters. The doctor in both situations, regardless of her intent, is respecting and complying with the wishes of the patient. So there's the claim that people may prematurely die because of an inaccurate prognostication. But the fact is that in general, and much more commonly, doctors think their patients are going to live a lot longer than they live, not a shorter time than they're going to live. And so that prognostication really doesn't matter for that reason, but also it doesn't matter in this regard because the decision to take the medical aid in dying medications is not made until the patient is really very close to death. So even if prognostication was wrong initially, it doesn't matter at the time that the patient ingests the medications. There's a claim that patients could be coerced into taking the drugs, and there's no requirement that a healthcare professional be present when the drugs are consumed. But think about this. There are often drugs in the home of patients in hospice, and there's no control over what happens to those drugs or what happens with the people in the household who may or may not coerce a patient to take more drugs than necessary in order to hasten their deaths. Of course, it's possible that relatives or friends may not act in the best interest of the patient, but if the patient has decision-making capacity and is making this decision for him or herself, it's really, it's going to be up to him or her to decide if and when they are going to self-ingest the medication. And consider, too, that we don't prevent healthcare agents or surrogates from making decisions that will result in death, even though there may be an occasional abuse. Okay, so let's talk about the provisions in New York's Medical Aid in Dying Act, which is now going to be in Public Health Law 28F. A person must be an adult that's 18 or older in New York. They must have a medically confirmed terminal illness. They must be given a prognosis of 6 months or less, be mentally capable, and be able to self-administer the medications, things we already mentioned. The individual must make an oral request to their attending physician, and the oral request must be recorded by video or audio and permanently stored in the patient's medical record. The individual must submit a written request for the aid in dying medication, witnessed by 2 people, neither of whom can be a relative or someone who might benefit from the person's estate or benefit financially from the person's death. Pretty stringent safeguards here. Not the kind of safeguards you have when someone is appointed to be your healthcare agent and there are 2 witnesses to the signing of the healthcare proxy. And by the way, I hope all of you do have a healthcare proxy and have appointed a trusted loved one, a relative or friend, to make healthcare decisions for you in the event that you are no longer able to make healthcare decisions for yourself. If you haven't done that, it's really important to do so while you're young and healthy, like most of you are, because anything can happen to any of us at any time. So additional requirements, the person must be a resident of New York State. That was not in our bill. The governor insisted on that provision, but it's relatively easy to establish residency in most states, and I think including New York. Again, we have those 2 physicians who must confirm the person's terminally ill, is making an informed care decision, and is not being coerced. And the initial evaluation of the patient by the attending physician must be conducted in person unless the attending physician determines that an in-person visit would result in extraordinary hardship to the patient. The attending physician must inform the requesting individual about all of their end-of-life options, including palliative care and hospice. And as I mentioned earlier, in most states, it's about 90% of those who die by medical aid and dying are actually in hospice at the time of their deaths. So they're getting the gold standard of end-of-life care. And as good as it generally is, it just may not be enough for some limited number of patients, some of whom might be suffering from pain, which simply can't be controlled. And while 95% of pain, in fact, can be controlled, it may be that about 3 or 5% of pain simply can't be controlled. Now there must be a mandatory mental health evaluation conducted by a psychologist, neurologist, or psychiatrist. That was not in the original bill. It was only that kind of evaluation would be done if either the attending or consulting physician determined that the person may not have decision-making capacity. Now it's mandatory, and so the mental health provider must confirm in writing that the dying person's capacity before a prescription can be written. We did not have a mandatory waiting period in our original bill that was passed by both houses of the legislature. There's now a mandatory period of 5 days. The governor wanted even more than that, but it was compromised at 5 days between when a prescription is written and when it may be filled. Again, unless the attending physician determines that the patient is not expected to survive that period of time. Of course, the patient can withdraw the request for aid in dying medication at any time, or not take the medication once they have it, or otherwise change their mind at any point in time, including right up until the time that they were prepared initially to take the medication. And the question is almost always asked, at least by a healthcare professional, and I think it should be asked by a loved one too. At the time the person has the medication in hand, are you sure you want to do this? Are you sure you're prepared? And you understand that once you take the medications, there's no going back. And I don't know of any cases, there may be a few, where the patient has decided at that moment that they are not ready to go forward and maybe never ready to go forward. But again, it's totally up to the individual to decide. Nobody has to participate in medical aid and dying, and religious-oriented hospice providers may opt out of offering medical aid and dying. And that's going to happen. There will be a number of healthcare providers that will develop policies which indicate that medical aid and dying cannot be done on their premises, even though the individual, if they are seeking medical aid and dying, can access it off the premises of the healthcare institution. So no healthcare provider is going to be held liable in any way for either participating in medical aid and dying or not participating. Malpractice insurance can't be conditioned on or affected by whether the insured participates in medical aid and dying. No healthcare providers are subject to, again, to civil or criminal liability. Private healthcare facilities may refuse to participate in MAID if they find it morally objectionable. And I think other healthcare providers may be able to do the same, even though it's not specified. But again, if they do so, the person can still access medical aid and dying in a facility or in their own home, if that's what they decide they want to do. Nothing really changes in any way with regard to employees. People are understandably going to be opposed to medical aid and dying for ethical, religious, or cultural reasons, and nobody has to participate, and that's a good thing. In fact, we don't want people participating who are opposed. Insurance benefits can't be denied based on any medical aid and dying actions, and insurers can't condition the sale or issuance of life or health insurance policies or set rates on the making or rescinding of a request for medical aid in dying. So actions in accordance with the law shall not be considered, and this is in every statute that's been passed, every law, it can't be considered suicide, assisted suicide, attempted suicide, promoting a suicide, mercy killing, or homicide, and the patient's death certificate must indicate that the underlying terminal illness was the cause of death. So in my opinion, and I think the opinion of many who've studied this issue closely, and I've studied it for some 24 years, there are so many reasons why medical aid in dying should be an option for the terminally ill, as it will be come August 5th, which is when our law goes into effect, 6 months after Governor Hochul signed the bill. And most importantly, there is really overwhelming evidence that it is a safe, ethical medical practice that benefits patients and causes no harm to anyone. So I believe that you all now have a responsibility to educate people about medical aid in dying, about the law and its benefits for those who might choose to access it, but also really to educate people who might be on the fence or people who are opposed. Have a discussion with them. Maybe you can change their minds. But again, so many people don't understand what the process is and what it entails and what the safeguards are and how many safeguards and requirements there are in order to go through this process. Once people do, and once doctors have learned about what medical aid in dying is, which is why there is so much support for the Medical Aid in Dying Act by doctors in New York, people then oftentimes do come around and support medical aid in dying. And I actually know of no organizations that have taken a position in support of medical aid in dying and who have then changed their minds and who have become opponents. On the other hand, lots of medical associations and other organizations have either become neutral or have changed their position from one of opposition to one of support. So I will take any questions or comments that you may have. And I appreciate your attention. Thank you very much.
One question that's come up at least twice is, who is medical aid in dying covered by Medicaid, Medicare? What's the expense related?
Medical aid in dying cannot be covered by Medicare. It's a federal program which clearly prohibits the use of drugs and to pay for drugs which might be used in medical aid in dying, or what they, I think, still term assisted suicide. On the other hand, it's possible that state Medicaid, but using state funds, can be used to support the payment of drugs for those who might not be able to afford it. But that's on a state-by-state basis, and there are only a couple of states right now which have authorized their state Medicaid program to provide such funding. I think New York should do so. It was not in our bill. I think it may be an amendment which could be added to the bill in the coming years. I think it should be, despite the fact that the vast majority of people have health insurance, which is going to cover the cost of the drugs or care, which the vast majority of people have the resources to pay for.
Robert, you have a question?
Yes. My question has to do with Alzheimer's and the dementias. Alzheimer's, to my knowledge, is uniformly fatal eventually, but by the time the disease itself is close to causing end of life, most of the sufferers of Alzheimer's are quite unsound mentally and would never pass a mental competence test. So that seems like a dilemma that would prevent this act from applying to one of the most widespread and debilitating illnesses that we are going to face going forward. Any comments or further updates?
First, you're absolutely correct in your analysis about people with dementia. by the time they are relatively close to death within 6 months, they would not have decision-making capacity and would not be able to access medical aid in dying. So what some people who have done, who have recently been diagnosed with a dementia, Alzheimer's, or something else, they might voluntarily stop eating and drinking. It's relatively premature for some people, but some people say they really want to avoid all the suffering that dementia might entail over a period of years. But the other thing that to consider is, and we have a form, actually, it's a dementia advanced directive for those who think that they may eventually have dementia, or even if they think they might not, but eventually develop it, that they can complete. It's on our website, the website of End of Life Choices New York, which so you can go there and download the dementia directive and complete it. It's not clear yet legally whether it's going to be honored. It probably will be honored in some institutions and probably not in others. There may have to be court cases that'll determine the legality of that kind of an advanced directive, but it's very clear, and you can make decisions for yourself in that directive as to under what circumstances you would want to continue to receive healthcare and treatment, and when you would not, when you would want to be hand-fed and when you would not. But there's a debate over the issue, as you may know, between those who say, well, there's the current self who's saying, I would not want to continue to live if I had advanced dementia and were suffering and didn't recognize my loved ones, was bedridden, did not appear to be happy, and so forth. And those who say, well, that's the former self, but what about the current self who is now in a situation where they don't necessarily appear to be unhappy and they still are swallowing when they're hand-fed? Of course, my response to that is it's really a reflex action at that point. It's not something which is being done voluntarily, so that in fact the former self decisions should be honored and respected. But that's going to take some time. We also have a bill pending, which I initiated in New York, which hasn't gone anywhere yet, which would allow healthcare agents to make all decisions for the principal with regard to nutrition and hydration. So that would include this type of situation, and in fact is designed to really focus on this type of situation.
So
we'll see what happens over the coming years.
David, can you explain that in more generic terms so people to make sure people understand what you just said? Because that was in the manner you said it is very clinical, and it goes.
Okay, I'm not a clinical person, so but let me try again then. So if you have advanced dementia, you cannot access medical aid in dying. That is clear, because you will not have decision-making capacity. What you may be able to do when you first develop a dementia is to voluntarily stop eating and drinking, which is something which is your legal right to do as long as you have decision-making capacity. And either before that or at the time when you have developed dementia but still have decision-making capacity, you can complete the advanced directive for dementia form that is on our website. And I would highly recommend that for people, because I think it's really something which hopefully will be honored and respected in the coming years, although it has not been tested in the courts yet.
So Patricia, just 1 minute, because I see yours, but Elise wants to know what happens when a family members, they don't support it. When
they don't support medical aid in dying?
Right, but the person wants it.
Okay. First of all, the person can decide not to tell family members. That is their choice. But if the family member knows, then it is up to the patient to determine whether they want to go forward, or because of the opposition of a family member, they might decide to not go forward. But in the end, it is the right of the patient to make the decision to either take the medications or not, despite opposition from family members. The same is true with withholding or withdrawing life-sustaining treatments. Whether, again, it's a feeding tube or ventilator, if the person still has decision-making capacity. Now, sometimes they will be persuaded by a loved one, whether it's a spouse or a child or sibling, that, okay, because I want to honor you, I'm not going to go forward. But in the end, the decision rests with the patient, him or herself.
Okay, so I want to explain something based off of how you said it, because it's often misunderstood. If somebody has a guardian, at that point, the guardian legally has some say in what is going on. So the guardian, because usually they're appointed when a judge has deemed that somebody does not have decision-making abilities, even though that is not always quite the case. So there is some, gray area there, but a lot of people misunderstand but a POA, just so you understand, cannot do that. The only time a POA has a decision-making factor is when the person cannot make it for themselves, and that does not apply.
Well, the POA is generally speaking for finances, not for healthcare decisions. The guardian might be able to make decisions unless there's a healthcare agent that was also appointed, in which case I believe the healthcare agent may still have the ability to make decisions. But the person, him or herself, because there's a guardian that's been appointed, probably does not have decision-making capacity, at least with regard to medical aid in dying. They might have the ability to make certain types of healthcare decisions, which are relatively easy to make if it seems clear that they understand what those healthcare decisions entail. They understand what the risks and benefits are of those healthcare decisions and the potential consequences of making that decision.
Okay, Patricia, you're next.
Thank you. Hi, David. I've been in the field for quite a number of years. I'm a retired geriatric social worker. And
your name is familiar.
Thank you for your presentation. Very clear, like your setting as well. I don't know where you are, but it looks very nice there.
Pelham, New York.
Very nice.
Westchester.
Yes. I was wondering if you were at liberty, since some of us have been on this fight for over 10 years, to share the nuance of the governor's decision-making. Clearly, many governors were not very happy and willing to pass this bill, but she was, and many of us thought that was quite courageous, given her clear faith in Catholicism and other things. She did make some recommendations that she felt more comfortable with, obviously, the 3-doctor statute and maybe some others. But I was just wondering whether, again, without anybody's privacy broken, how did you find the nuance of getting this done? And congratulations.
Well, thank you. I think the governor was courageous to an extent, and she was really good at the end. She met with 6 advocates, people who had lost loved ones who would have wanted medical aid in dying for themselves. She met with them privately before a press conference that she held, where she announced that she was going to sign the bill. And
yes, I saw that. That was very nice.
I was there.
Yes.
Mandy Zucker, who was the executive director of End of Life Choices New York, is here as well today, and she and I had front row seats for that press conference. I think because we were so much heavily involved during the whole process of getting the medical aid in dying bill introduced and finally enacted. And the governor's remarks were terrific. She was so good, and she did mention her Catholic faith. And she did mention that she considered all points of view, and she took a long time. between the time that the bill was ultimately passed by the state Senate in June and the time that she signed the bill into law in February. And she really did consult with a lot of people to make sure that she was doing what she thought was the right thing. Now, politically, it was clearly the right thing. There's no because, as we know, a significant portion of New Yorkers support medical aid in dying, including large majorities of Democrats and a majority of Republicans, and virtually every demographic in almost every poll. So, but still, in the end, her statement was terrific. It was very moving, and we were so happy to be at that press conference where she announced that she would be signing the bill.
Do you think when August 5th comes and the first person who will be in that position, do you think it'll just be quiet into the big night, or do you think there's going to be more discussion about it if and when it happens? It will happen, whether it happens on the first day, we don't know. But how do you think the public will have an opportunity to either know or respond that their work, your work as advocates, help somebody?
Well, of course, firstly, the person will not be able to access it on August 5th. They have to go through the process, right? Which we know is going to take generally 5 days at minimum, and oftentimes it takes a lot longer than that. But for those who are very close to death, they may want it immediately. And whether or not it gets publicized really is going to depend probably on the patient, him or herself, whether or not he or she wants it to be publicized. And if so, there may be some good media coverage. And if not, we're probably not going to know that it happened. Some of us may know because we might be working with healthcare professionals who are involved in the process. And I should mention that End of Life Choices in New York, along with the American Academy of American Academy of Aid and Dying, are working together. And every 2 weeks we are having meetings on implementation of the Medical Aid and Dying Act to hopefully ensure that when August 5th comes around, that we are going to be prepared. There are going to be healthcare professionals available, including, of course, doctors who are necessary to work with patients, providing end-of-life care to those dying patients who might decide ultimately to access medical aid dying.
So we have a lot of questions still. So normally we end at 2:00 or 3:00 Eastern, but if anybody wants to stay on, as long as David's okay, that's fine. But just for the first question.
Well, I'm sorry, I have to leave by 6:15.
That's fine. Oh, yeah, don't worry. So one of the questions that somebody asked, which I do understand the question, Beryl, is if somebody has ALS and they have that cognitive ability, but they don't have the physical ability, is there a way for this to be, because they're incapable of self medication. So is there still a way for this to happen?
People with ALS do access medical aid and dying. In fact, of any disease, the highest percentage of people have ALS, as opposed to, comparatively speaking, who access medical aid and dying. So even a much greater percentage than people with cancer, even though a lot more people with cancer access medical aid and dying. So there does come a time when a terminal diagnosis can be made of the person while they still probably have the ability to ingest or to push a button for a tube that will ingest the medications into their body. And so there will come a time when some people who were thinking about medical aid and dying, who might have ultimately wanted medical aid and dying, will not be able to ingest the medication. Now, in the years to come, it may be that laws will be amended to allow something more than what's permissible now. But for the time being, it seems like probably the vast majority of people with ALS who really want medical aid and dying are still in a position where they can self-ingest, having now been given a prognostication of 6 months or less.
Reuben, you're next.
Yes, hi. Can you hear me all?
Yes.
Yes, great. Thank you for having me. So I'm a long-term hospice volunteer, and I've been with patients who have opted for voluntary stop eating and drinking. And what I can say from experience is that VESED as well as medical aid in dying require a team. It's not just the individual, because oftentimes that individual will be in a compromised situation. They won't be able to order the medication, and there's the whole process to go through. So I think it's important to recognize for people who are considering medical aid in dying and VSED that they can't really do it on their own, and they do need that support of advocates.
You're absolutely right. There have to be caregivers involved and people who are going to be supportive of the person, particularly if they're in home hospice, which the vast majority of people are who access medical aid in dying. So it cannot be done easily for someone who might be relatively isolated. So good points.
Go ahead, Mandy.
I just wanted to say somebody had asked about, the first person that is going to utilize medical aid in dying. We get a ton of calls at End of Life Choices New York from reporters that would like to highlight and bring more awareness to this dignified way to die. We also have not a ton, but a lot of people that are interested and think that they could potentially be the first person to use it. Many of whom do not want to be on television and be, interviewed by reporters. I completely understand their point of view and, the fact that they want to remain private. If you or someone is interested in medical aid in dying and would like to use their story to bring more awareness, I would really encourage you to reach out to us, because we have some very, very sensitive reporters that we've worked with, CNN, CBS, like big, outlets that are really looking to help us to bring more awareness. And if you think you would be interested in something like that, I just wanted to let you know that we can put you in contact with them.
So I know there's one or two more questions. So one of the reasons this was really important for me personally is my dad lives in a state that does not allow for it. And, and he thought for sure Google could help him figure this out on his own. And I promise you, people, support the person who needs the support, because unfortunately my father lingered for a day and a half instead of the 5 or 10 minutes that it should have been, because he was not able to access the proper care. And it is a very hard subject. I have a child who was born with chronic illnesses. We've discussed these things almost every day of his life, and he's an adult now. And, so one of the questions here that's been asked multiple times, and I'm very curious about the answer because of where I know my son's feelings are too, is, can somebody still donate organs or tissue or anything if they've used medical aid in dying?
Probably not, because they're not going to be on a ventilator, which I think you almost have to be in order to donate organs. But yeah, I think that I'm not a clinical person, but I think that's what I've heard.
That's fine,
And there's
We have a question. Oh, sorry. I was going to ask Francis's question. Do patients have to indicate in advance that they're interested in accessing MAID, or can they just make the request the day before?
Well, not the day before they're going to die.
Well,
but they can make.
How far in advance do you have to make the request?
They can make the request anytime, as long as they have the terminal diagnosis. So once the terminal diagnosis has been made by usually it's going to be by a hospice medical provider, then they can start the process anytime after that if they have an interest.
Okay.
And again, they might get the drugs and never and have them in and store them for even months. And as I mentioned earlier, the process usually takes about an average of 6 or 7 weeks from the time that the first request is made until the time that the drugs are actually taken, if ever.
Is there any final question? There was something about New Jersey is using MAID in long-term care settings. Is this something that we could do in New York State?
Medical aid and dying can be used in any kind of setting where patients are. It depends upon what the willingness is of the setting itself to provide to allow medical aid and dying in that setting. If you're talking about long-term care nursing homes, I think a lot of, certainly, if not majority, many people who are nursing homes do not have decision-making capacity and wouldn't be able to access it in any event. But it can be done in long-term care facilities, absolutely. I just want to make one other point. If Mandy's here, our program director, Natalie Chara, is also has been on at the meeting, and any of us are more than willing, would love to speak to any other organizations or groups that any of you might know of that might be interested. If you could either reach out to yourselves or reach out to us and give us the names and the names of people that we might contact, because this, again, is such an important issue for so many people that know about it. But again, 50% of the public probably in New York does not know about medical aid and dying.
So I'm going to add another question I just thought of. So a lot of states, Illinois being one, and I live in Illinois, has gone to shared decision making instead of appointing guardianship because they want the person to try to have as much decision making factor as possible. So that, I think, is really going to get to be interesting of what happens if it is shared decision making. You know, if the person wants it and the other person doesn't. That would be one of my, I guess, concerns of how that would be handled at that point too.
Yeah, and I don't know the answer to that. Again, it's a matter of determining whether or not the person has decision-making capacity, him or herself, even though there is a shared decision maker. I think it's going to be determined by decision-making capacity of the individual who is terminally ill, is my guess.
Yes. So Francis, where you're asking about legal documents, they have it all on their website, and I will make sure that Emily shares it all when she sends out the recording. And if there's, and all of this has been recorded, so anybody who wants to see it, will get an email telling you guys, giving you the link to it, and it will be posted on our YouTube channel in a week or so. And please share it with others because it is really important.
I also want to add that we can add end-of-life choices to our resource list so that anyone can find you through visiting our website. So we really appreciate everyone coming today and staying late because we typically end by 3 p.m. I want to also thank you, David Levin, for your time and expertise and for reminding us that we should be, everyone should have a healthcare proxy. So please check that your healthcare proxy is in place. And then we look forward to seeing everyone next month on April 28th, when we will have Marcus Engel, who will speak on compassionate communication at the patient end of the stethoscope. So thank you to everybody for today's session.
Thank you very much.
Thank you for having me.
Thank you, David.
Thank you.